Welcome, everyone. Thanks for coming out on this beautiful afternoon to discuss abolition and the death penalty. I'm delighted to be here with Alex Hoag, who's senior counsel at the NAACP Legal Defense Fund and has an incredible background in death penalty, which I'll tell you about in a moment. But this couldn't be a more critical time and an opportune time to talk about the death penalty. Because really, with the election of President Donald Trump, I think that the history of death penalty in the United States and of the abolition of the death penalty in the United States took a turn. And we're right in the middle of that turn right now. And how it's going to kind of ultimately work out, I'm very optimistic that there will be abolition of the death penalty in this country. But it's going to require a different route now as a result of the election of President Donald Trump, a route that had been envisaged as being one that was going to go through the United States Supreme Court. And I think most legal scholars, most lawyers were prepared to see the court declare the death penalty unconstitutional within the next decade or so, if it had been a Clinton Supreme Court and Democratic appointees. But at this point, it's going to be a different route, but I think it's going to happen anyway, abolition. And it's going to be a route that's going to take us through the states. And I think we just started to see that in California with the governor's moratorium. So it's a critical time to think about the death penalty and to think about its course, its history, and where we're going. So, and I couldn't be more delighted to welcome Alexis Hoag here today. Alexis joined the NAACP Legal Defense Fund in October 2017. And before that, she spent 8 years down in Tennessee litigating directly death penalty cases as a federal public defender in the Capital Habeas Unit of the Federal Public Defender for the Middle District of Tennessee in Nashville. And today at the Legal Defense Fund, Alexis represents both federal and state folks who are sentenced to death. She's also involved in some other litigation and policy work on particularly regarding the supervision of the NYPD after the stop and frisk litigation. And so she has her hands in a lot of different areas, also life imprisonment without parole questions. And so it's really, truly delightful to have you here at Columbia and for us to be able to have this conversation together with the students and friends. So let's start then big picture. And let's start really talking about the likely future of the death penalty in this country. Mm-hmm. We're going to touch on all of the pieces during this conversation. We'll talk about litigation of race discrimination in the death penalty and innocence claims and methods and lethal injection. But I really want to start with an overarching framework.
Sure.
Yeah. So tell me what you think about the likely future path of capital punishment in the United States.
Mm-hmm. So I was at the Federal Public Defenders in Nashville, and I was working mostly post-conviction. Mm-hmm. So it was folks that had been sentenced to death in state court, and they exhausted their state appeals, and they were appealing in federal court. Mm-hmm. And that's when my office took on their case. And I remember leading up to the last election and thinking, my job is going to be obsolete, and how fortunate, to be in a field where I can represent individuals, bring their humanity before the court, and my position will be obsolete. And it was sort of a running joke, in the office. What are we all going to do? And obviously that didn't work out. And it's been such a sharp turn. Mm-hmm. And I think looking at the hostility from the Supreme Court now with Justice Gorsuch, and his recent decision in Bucklew.
Right.
That the Eighth Amendment doesn't guarantee a painless death.
So for all of you who aren't completely up to speed on this, the Bucklew decision was the most recent litigation involving lethal injection. It was a case where Mr. Bucklew has a special disease, tumors that are at risk of being inflamed and having serious problems if there's a lethal injection. And And last year, as a result of, I felt as a result of the Doyle-Ham case, which was a case where someone also had health conditions that would render it very difficult to have a lethal injection, and when the court ultimately let that execution go forward, but it had to halt because after 2.5 hours they weren't able to find a vein, that I would have thought that the Supreme Court had been somehow chastened by that and would have acted differently in the Bucklew case, but they turned it down recently. And you want to talk a little bit about the opinion there?
just to mention the hostility that comes from the court and from this clear conservative majority. And so, as you mentioned upon opening, that the real battle now is in each individual state. And LDF thinks very critically about how to eradicate the death penalty. And we've been on the forefront of litigation in getting rid of the death penalty, beginning with McCleskey versus Kemp, which obviously was a loss. Buck versus Davis, which was a more recent win, which said that racial bias shouldn't have a role in sentencing to death.
Let's just stop for a second and explain the Buck case
a
little bit, because
yeah.
it's a really important case, recent, and it's one of the rare cases where the Supreme Court still has been kind of favorably inclined to address issues of race. Tell us a little bit about that case before.
Sure, this was a Texas case. Dwayne Buck was an individual that had been sentenced to death in Texas. And his case had a lot of procedural barriers in place, which happens the longer that you're on death rows, you work your way through the appellate courts, and particularly coming into federal habeas. And so LDF got involved in his case really in the 11th hour. And the legal mechanism, the procedural mechanism that was used to get before the Supreme Court is sort of this 11th hour litigation. And he had dates set in the past. And the issue was, there was this medical expert, psychologist from the defense who testified, and it was the defense attorneys that put on this testimony. And this defense expert said that Mr. Buck is guaranteed to be more dangerous because he is black. And so the jury goes back and they deliberate and they say, well, he's bound to be dangerous in the future because of his race, which is this immutable characteristic. And this expert had testified in a number of cases throughout Texas. All of them had been overturned because they found that this expert's testimony and findings were problematic, not based in science. And Dwayne Buck's case was the only one where he was still under a sentence of death pending execution because of this defense expert's testimony. And so the argument there was that Mr. Buck had ineffective assistance of counsel, which all defendants are guaranteed to have effective counsel via the Sixth Amendment. Right.
I mean, it was remarkable that it was actually presented by defense counsel. I mean, sadly, not remarkable. I mean,
when you do the litigation, it's not remarkable,
right,
yes.
When you work in this area, you get a strong sense that actually many of the attorneys representing persons accused of a capital offense really have issues of racial discrimination themselves that comes out very much in the way that they speak about their own client. And here it was actually defense evidence.
Exactly.
But this makes me think particularly, so with the Buck case, and we should talk about the other cases that address racial discrimination, but recently the case of Vernon Madison that was decided in January favorably to Vernon Madison. And that case involved the question of whether dementia would satisfy the incompetence to be executed standard. And for some reason, I think there were some racial overtones to that case as well. But it strikes me that if there's one place where the court might still be favorably inclined in the death penalty area, it's in the area of racial discrimination. Do you feel that too?
And I'm probably one of the more biased people because I work for a racial justice organization and everything we do is about putting race in the forefront. But yes, and going briefly back to Buck, it was Chief Justice John Roberts who wrote that decision.
Right.
And said that race doesn't have a place. We're in sentencing, and that we punish people for what they do, not who they are.
Right.
And so that really seemed, okay, we're turning this corner, that if we show this conservative-leaning court that there's egregious instances of racial bias, surely they can rule in the defendant's favor. But then you had the denial of cert in Keith Tharp's case.
Right. And tell everyone about that case. That one is about a prejudiced juror that is just the... Go ahead.
Yeah, it's shocking and surprising to hear of it, but it was a Georgia case. I want to say it was probably litigated at trial, maybe in the early 90s.
Yeah.
And so during post-conviction, after the conviction, attorneys, investigators, they worked the case top to bottom all over again. And so one of the investigators was talking to jurors. And you knock on, I've done these interviews, you never know what to expect, but you knock on the door, and often people let you in. TV might be blaring, they're chain smoking, and no one has talked to them about their service on the jury. And so they're quite interested and engaged and often welcoming. And so this individual who was on the jury said that, there are two types of black people. There are good black folks and they're N-words. Of course, he didn't use the phrase N-word.
Mm-hmm.
And I sentenced Keith Tharp to death because he's an N-word.
Mm-hmm.
And the victim was, part of the good black folks.
Mm-hmm.
Unequivocal. And he signed this affidavit. And so this case worked its way up, and the first time it appeared before the Supreme Court, they sent it back to the U.S. Court of Appeals and said, you've got to get this right, you've got to address this matter. And so again, the U.S. Court of Appeals denied it, and so it went back up before the U.S. Supreme Court. LDF acted as amicus, so it's a friend of the court brief that says we have an interest, we have some knowledge, we want to weigh in and help you decide this case. And so our argument was that these procedural barriers that are in place, this wasn't raised, we recognize this wasn't raised the first time, at trial, this evidence wasn't even available until post-conviction, and these interviews were conducted, and they got this affidavit. So these procedural barriers that are in place that say normally you can't hear these kind of claims, you should sort of waive those in this instance of egregious racial bias. Look at Buck, where you said, racial bias doesn't have a place in sentencing. And the Supreme Court said no. So, when I still remain hopeful, you have to be hopeful when you do capital litigation.
Right. I mean, so that raises a couple of things. So one is, of course, the procedural bars and the procedural default in these cases, which you'll all learn as attorneys that courts impose procedural bars if a claim is not raised at the earliest stage, at the trial stage, really. So if an objection isn't made at trial, or with a juror it would be on the first post-conviction stage, then there are procedural bars that come into play, and the later courts will not address that question because it hadn't been addressed. It was too late. Mm-hmm. And that's probably one of the greatest impediments to these cases receiving fair treatment.
Mm-hmm.
I mean, most of these cases spend years in court, but they're hardly ever addressed on the merits, and it's always a kind of a battle over these procedural bars.
Yeah.
That is likely to get worse with this court. I can only imagine. That's likely to get worse.
But I mentioned I still have hope.
Yeah, right.
Because of the Flowers case.
Right. So that piece is likely to get worse with this court.
Procedure, yeah.
On the question of race discrimination, though, a few optimistic lights,
Yeah.
okay, including Flowers. So why don't you tell us a little bit about that?
Yeah, and I'm hoping that these cases, given the egregiousness of the racial bias, they've been reported in the media. And I think with Flowers' case, that was a Mississippi case. There was a podcast or two on it, I think. There's a lot of media generated, but he'd been sentenced to death, and there were 6 retrials. Or I should say 5 retrials, so 6 trials total.
6 trials, right.
And multiple trials were overturned because of racial discrimination in jury selection.
Right.
And that was the issue. I mean, there's always a number of issues that exist in these cases, a number of injustices.
Right.
But often it gets whittled down to one sort of key issue.
Right. And it's a Batson challenge where the prosecutor used, I think, 5 out of 6 of the prosecutors, I don't know if it was a man or a woman,
Man.
peremptory challenges meant to eliminate African American potential jurors. So out of a pool that could have had 6 African Americans on the jury, the prosecution essentially eliminated 5 of them.
And this is after previous trials in which he used, I think it was maybe 14 peremptory strikes to get rid of, 14 African Americans, and then
Right.
another trial where
Right.
he used 7 to get rid of,
Right.
6 or whatever
Right.
it was.
Right.
So there was the history. And why I say that case was hopeful, I was at the oral argument for that.
Okay.
And so you had Justice Kavanaugh, sitting on the far right because he's the most junior member of the court, and he asked the state of Mississippi, and he said, can we not consider the history? Isn't the history of this case important? This is the 6th trial. You've got the same prosecutor. He's got this record of racial discrimination and jury selection. Is that not relevant? And I mean, we were all sort of shocked that he was the one asking these questions. But as a student, he wrote his note on Batson and how it needed to be enforced. It was sort of this tentative sort of test for how to determine racial bias, discrimination, and jury selection. And he was really arguing that it should have more teeth to it. And that was the student note he wrote, I think, in maybe late 80s, 1990. And he was very concerned with it. And it seemed that Justice Roberts also was troubled. They're all very troubled. You see
Right.
your eyebrows troubled.
Right. Yeah, most people who came out of that argument felt that it went well for
Yes.
for
Mr. Flowers.
For Mr. Flowers. On the Batson, it's actually interesting because when Batson became the law, it overturned a decision, Swain versus Alabama, which was the old standard for striking a jury, and the Swain standard was. It was an extremely high standard. You had to prove that in all of the previous cases, the prosecutor had used the peremptory strikes against African Americans.
And Mr. Swain didn't even get relief
Right.
in that case when
Right.
the legal precedent prevailed.
Right.
He didn't
Right.
even get relief
Right.
based on the law that came out of his case.
Right. But it was interesting because to a certain extent, Batson tried to move the needle towards just your particular case. But it's interesting now that it seems as if it needs to be informed by the history. And so we'll see what the court does. But again, Chief Judge Justice Roberts is being the swing vote.
He's the new
here.
Kennedy. Who knew?
He's the new Kennedy.
Yeah.
But on these questions of race, in light of Buck, it seems as if he might be movable in a way that on these other issues, and that's going to be the predominant majority of these other issues, I don't see 5 votes.
No.
We saw it on the Buckley case, lethal injection methods, challenges. I don't see 5 votes. Also on what was very disturbing about, I think it was Chris Price's case. No, it was the case before Chris Price. But one of the recent cases, which was again a cert petition from the 11th Circuit coming on the day of the execution, that just happens, and I mean that's inevitable.
Yeah.
In part, it's inevitable because the 11th Circuit sits on it for a few days, and then you end up on the day of. But the court justices, or many of the justices, or 5 of the justices, were basically saying, look, we're not going to look favorably on these last-minute stay applications, right?
Yeah.
And so that's a devastating. That would be devastating because there it just covers the whole swath of stay litigation, basically.
Yeah.
So that's not very promising. And so when you combine all of this stuff, I think basically the future of abolition is not going to be immediately through the Supreme Court. I think the decisions that are going to be coming down are going to be pretty devastating.
Which is your opening question then.
Yeah.
The states.
Yeah, the
Which
states.
we were going to get
The
to
states,
eventually.
Which we're going to get to. Yeah. But I mean, you're entirely right that when you were, in Tennessee in 2016, it really felt as if we were on a course.
Yeah.
It really did feel like we were on a course. And professor colleagues, Carol Steiker, who you know, and Jordan Steiker, had just published a book called Courting Death, which kind of charted the constitutional path to abolition. And
It became
things have
obsolete,
changed.
yeah.
So the states.
Yeah.
So it seems as if the path will be through the states. How? What are the
Yeah.
different pieces of that, do you think?
Yeah, well, it's looking at the favorable laws that are in states and at their individual constitutions, which in some areas go a little bit further than the federal constitution, and which states can do. You can't be below, the federal constitution, but you can go a little further in the protections that you offer. And so, looking at Washington State.
Okay.
And the Gregory case, and that was one where I think there were 8 individuals on death row, 5 white, 3 black. And the decision, based on a lot of empirical research and statistics and studies and scholarship, but it reflected that Washington and the way that they administered their death penalty, it was racially biased. And that was the decision. And the ACLU was instrumental. Jeff Robinson is in their national office in putting together the scholarship for that amicus brief. But that was the focus, was that in Washington, even with our small number of individuals on death row, under Washington state law, this violates, basically it's the equal protection and due process clause that the state offers. And so immediately everyone started thinking, well, what can we bring in our states? And we're not all in silos. We do talk, the Capitol community. There's lots of listservs and databases and conferences where people get together and strategize. And so Pennsylvania became sort of the next state with its challenge. And these are challenges through the courts. There's another challenge happening in, the different legislations and lobbying. But in terms of working through the state courts and within the state constitutions, you had the Commonwealth. Their constitution, it's not cruel and unusual. I think it's just cruel. And so the precedent in Pennsylvania basically says that the way that the Commonwealth looks at cruel punishment, it offers greater protections than cruel and unusual. And so there's some mechanism, and I don't traditionally practice in the Commonwealth, but it's called like a King's Bench petition. And so even though this case was in federal habeas, they filed a Commonwealth King's Bench petition before their Commonwealth Supreme Court and said, we want you to hear this case, this challenge. And the court granted the petition to hear the merits of this case. And it wasn't even talking about the sort of facts of the crime. There were 2 individual cases that got consolidated. One white defendant, one black defendant. But the briefing didn't discuss the facts of the crime, other than that, on this date, these people were tried and convicted and sentenced to death. But it was really about the history of the operation of the death penalty, modern death penalty, so post-1976. Who was receiving the death penalty and why, and it's all sort of focused mostly in Philadelphia. It's mostly black defendants, but even the biggest indicator isn't just the race of the defendant, but the race of the victim. So it's mostly people that are accused of killing white victims, so that black life isn't seen as worthy.
Which is the basic holding. I mean, we studied that in McCleskey versus Kemp, or the finding.
And so that was really the challenge. It was this more global sort of challenge, and not just the individual cases. And there was a lot of, David Baldus obviously had produced a lot of scholarship, and because he was in Pennsylvania, so much was focused in Pennsylvania, but also looking at Batson we discussed earlier, but jury selection and racial discrimination in jury selection. And LDF weighed in and filed a brief, and we did a slight survey sort of the scholarship that's out there and the findings that show that Pennsylvania's death penalty was violated there, or rather was racially discriminatory, and talked about our history litigating McCleskey versus Kemp. But that's pending. But a decision should come out this calendar year. And that court, that they see themselves as nonpartisan, they do lean left. And you've got, Larry Krasner now as the DA. In Pennsylvania, district attorneys hold so much weight. I don't mean the individual ones, yes, but really it's the head of the office, because they can either green light or not whether to seek the death penalty. And he has said he doesn't want to seek the death penalty anymore. And Philadelphia is the largest producer of the death sentences in Pennsylvania, and so that's definitely a shift in the other direction.
So what we have is now we have kind of state by state issues to deal with and address, basically. And when you have a state court like Washington State Supreme Court dealing with it there, Pennsylvania, Arizona has a problem with the fact that they don't really narrow their death penalty, their categories, so that approximately 98% of homicide cases or murder cases are death eligible. So there's going to be a lot of litigation around that in Arizona. So you really have this sense that the work is going to be at the state level.
Yeah.
In terms of legislative changes as well at the state level, there are lots of states that are considering not having the death penalty for someone with mental illness.
Serious mental illness, yes.
Serious mental illness. Where is that going on right now? Do you know which states are doing that?
Yeah, so I know Tennessee, there's a coalition, and there's this group, national group, called Conservatives Concerned About the Death Penalty. And one of their biggest concerns is that it's expensive. But one of their other concerns is that folks with serious mental illness are caught up in this system. And I think that shows that folks across the aisle, they have proximity to mental illness.
Right.
So it's something people can rally around.
Right.
And so that's been quite effective in states. You don't normally think of Tennessee as a state that would narrow the category of eligible people who could even get the death penalty.
Right.
And this really comes on the heels of prohibition of execution of the intellectually disabled.
Right.
Which was the 2002 decision. And intellectual disability is what used to be known as mental retardation, but the fact that, because of this characteristic, you are less culpable of this crime, and what good would society do in punishing someone who is less culpable given their intellectual disability, given their serious mental illness. So I know there's traction happening in Ohio, I want to say Nevada, North Carolina, but Tennessee, and it's something that LDF is really trying to elevate. We have our strategizing conference on the death penalty every summer. You spoke at it last year in July, but that's one of our key pieces is looking at what each of the states are doing, not just in the courts, but legislatively, policy-wise, with serious mental illness.
Right, yeah. And many of these efforts always had begun at the state level. So on the question of intellectual disability, or what we used to refer to as mental retardation, those were state-by-state efforts in the same way as efforts on mental illness. And it was as a result of states individually eliminating the death penalty for a particular category of individuals who suffered from serious intellectual disabilities. The aggregation of it ultimately got the Supreme Court to say it was unconstitutional. But I mean, I think we're less likely to have that Supreme Court kind of push the pedal on it, but I think we're more likely to see the states assume a certain responsibility and in this way kind of reduce or cut out categories of individuals who would be subject to the death penalty. And of course, the result of that is ultimately a dwindling of the numbers of persons who are executed and sentenced to death,
or even eligible.
And I mean, you can see it. You can see the path. Well, this is the number of executions, right? With a much higher level, about 100 executions at the end of the 20th century, 1999, but then consistently going down to the last 3 years. The last 3 years have been relatively the same, 20, 23, 25 for 2016, 17, and 18. But it's that kind of bringing down of executions and also of bringing down of the numbers of person sentenced to death, which is a key way of intervening at the state level with the kind of the aggregate of the states rather than through the Supreme Court. And so here too we see kind of consistent declines in the number of persons sentenced to death in the United States from 1999 at rate of 284 down to 42 last year, 42 persons sentenced to death, which for a country the size of the United States is a relatively small number of persons sentenced to death. So and of course the result is that the number of persons on death row has been declining. You see an exponential increase, of course, from this period here was when the death penalty was held to be unconstitutional in 1972 in Furman versus Georgia. And so there was this drop while states adopted new death penalty statutes with an ultimate, a pretty exponential rise, but gradually since about 1995 a decline. And this is going to be the next question, but what you can't fully see on here is the amount of the decline in this last year. I should have augmented this, but basically this drop here is due to California, right? So there were 727 people on death row in California of a total population of about 2,700. So basically it went down from 2,700 to 2,000 people on death row as a result of California. So let's
My
think
state.
about
I'm
that.
actually
That's
from
your
there,
state. Okay. So it was a very courageous act by Governor Gavin Newsom. What are your thoughts about it? And what do you think it tells us about kind of the future for other states as well?
Yeah, I mean, it was a massive message. California, I mean, some folks don't realize that California has a death row, but California has the largest.
Yeah, huge.
Over 700.
Yeah.
And I think the next closest state is maybe like Texas or Florida with like 200, 300 or so.
Right.
So it's quite large. And then they're very slow in terms of post-conviction litigation because there just aren't enough lawyers with the necessary expertise to take the cases. And then they just sort of sit at each level waiting, pending sort of disposition. That was a very brave...
But it's also because California has a remarkable system of appointment of counsel.
Yes.
You kind of can't compare California.
No, you can't.
Lawyering in California on these cases where people can be assigned to a case and be properly paid as an attorney and represent one person, and that so
that
there
can be
is
your practice, yeah.
Yeah, that can be your practice.
Yeah.
Is one or two clients, and those are your cases, which is the way it
should be.
I mean,
relative to Alabama, which doesn't have a mechanism for state post-conviction.
Right.
Yeah. I digress. But California.
Yes. Yeah. So as a result, California has had this really slow trajectory. But do you think that there could be a kind of boldness contagion effect or something from this decision? For sure.
There's this organization. It's called the Justice Collaborative Center. And it's really like a criminal justice consulting kind of firm. A lot of former public defenders, folks that were doing direct representation but really wanted to take on a more sort of global macro take at issues within the criminal justice system. And they basically do consulting for politicians, for organizations, and they worked very closely with Gavin Newsom's office to how this would roll out, what the media sort of strategy would be. It was a very thoughtful, very mindful decision, which it would have to be because it was such a wide sweeping decision.
And he had said he was opposed to the death penalty before the election, right? So he had kind of made it clear that he was just morally opposed to the death penalty, right?
And he's a big message kind of guy. I mean, I think it was like 2004 where he was mayor of San Francisco.
Same-sex marriage.
Same-sex marriage, yeah. You can do here in San Francisco.
He did it in San Francisco way before anyone else was kind of on the bandwagon.
Talking about it,
Right.
But I mean, look what happened with that decision, right? It's now you can get married everywhere. He was mindful.
There, thanks to the United States Supreme Court.
Yes.
And hopefully we're not going to see a retraction on that one. Go ahead. At the United States Supreme
But
Court.
it sends a very strong message. And California is one of those states. And looking at sort of the numbers here, it's amazing that it's not, when I think the last number was like 42 of, I don't know if it was death sentences or executions of the year, but it's not like one in all the states that operate the death penalty. It's really just like select counties.
Yeah.
And so in California, it's like San Bernardino County, Orange County, some of those inland counties are producing all of the death sentences. And so...
And Texas, and two counties in Texas are producing the vast majority of the executions. Yeah, go on, sorry.
Yeah, and so it sends the message that here's this state where we've got certain counties that produce some of the largest numbers of death sentences. We've got the largest death row in this state. We're going to go ahead and put a moratorium on this. And I want to say now we've got 20 states that prohibit the death penalty, but then there are about 4 with moratoriums.
Yeah, right. I've got that here. 20, you're right, exactly, yeah. 20 states that have abolished the death penalty, but then there are also...
So you've got California with its governor instituted moratorium, Colorado, which I'll get back to. That's got some troubling trends there. Okay. Pennsylvania, and I want to say Oregon. But Colorado, there are 3 individuals on Colorado's death row. All 3 are black. All 3 were prosecuted by the very same county. And they all even went to the same high school. And so when you look at how sort of localized the death penalty can be, and the governor, Lopin, I mean, he might be running for president soon.
He is, I think, his name. Right? He's on the list.
Or the former, I think there's a new one now.
Right.
But, there were just really troubling trends looking at how localized and how racially sort of discriminatory the operation of the death penalty was there. But that was one where, they're no longer going to be carrying out any death sentences.
Right. And so... But I think that there's a possibility of a kind of a contagion effect, particularly when you look at the reaction to the governor's moratorium, because actually 2 of the leading younger presidential Democratic candidates, Beto and Kamala Harris, came out against the death penalty in response.
Which is huge for Kamala, as a former prosecutor, who defended hundreds of death sentences.
So her background is a little bit complicated. Her background is a little bit complicated. She did oppose the death penalty for much of her tenure, but then she defended it as Attorney General when a federal district court had struck down the death penalty on amazing constitutional grounds. It was actually a remarkable decision. But there she kind of actually flipped. But so she's got an ambivalent relationship. But it is remarkable that she has come out. She came out against the death penalty. Beto as well. And so that's actually, I think that's remarkable. That's huge. I mean, you didn't get that for presidential candidates in this country, right?
You used to run tough on crime. That's how you got elected.
I mean, surely, we know President Clinton was just an abomination on the death penalty, and the whole Arkansas episodes were just unconscionable. But to have presidential candidates now who are serious contenders saying they're opposed to the death penalty, I think that reflects something remarkable.
I agree.
So, and that I think is a reflection of the California governor's courageous move, and a reflection of the fact that in this country, and actually across the world, most of the abolitionism, a lot of the abolitionism happens through leadership of a particular individual opposed to the death penalty, rather than through, a lot of times it's not through a public referendum, because most of the times there's still support for the death penalty at a public level. Although across the country, we're starting to see the gap kind of really close. These are national numbers, so it's the Gallup poll, and what it shows was there was one point in the history of America in about 1966 when there was actually greater opposition to the death penalty than support for the death penalty, in 66. And then at the point at which the United States Supreme Court struck down the death penalty, but then states started to resume, the momentum kind of increased until the mid-1990s. It's possible that this increase was due in part to crime increases in the United States. So the homicide rates really did spike during the 60s, 70s, 80s with 3 spikes. So it was during this period. And of course they started...
Use, there was particular drugs that were available that were really sort of driving that up.
Right. It's kind of the last spike being particularly about crack cocaine epidemics. But starting in 91, crime goes down, and in any event, since then, kind of consistently, we've seen this decline where it's basically at 55 in support, 41 against, which that's starting to get pretty close.
Yeah.
And this is not, if you ask people if the alternative is life imprisonment without parole, then actually the numbers flip and there isn't a majority in favor of the death penalty. So I mean, we have leaders who are showing some moral courage at the state and at the potentially federal level. And we do have popular opinion that is kind of getting tighter in this way, which are all kind of promising and should impact at the state level, even if it doesn't have an impact at the United States Supreme Court, right?
Yes.
Right. Yeah. Okay, so let's see. The cost. You had mentioned costs too, and that's something else that seems to be an important issue. Do you want to say a little bit about that?
Yeah, I mean, there's wonderful studies out there that say it's not just the cost of incarceration that's higher to operate a death row, but it's the cost of the actual trial.
Right.
Because people with money do not get sentenced to death.
Right.
And it's indigent people that come from under-resourced communities in every definable way. And so the state is paying for that representation. Because of very important litigation, within the last 40 years or so, defendants have a right to have experts assist in their defense. They don't always get all the experts they ask for, but so there's cost associated with just paying for all the individuals that have to be in place to represent anyone that is facing a death charge, and then the cost of the prosecution and their sort of experts on the length of the trial, and so it's not just looking at the length of the incarceration and all of the appeals, which people complain about how long that can take, but it's the actual trial cost. I don't know, it's like 10 times as much maybe, or it's a significant difference.
There was just
between
a great article about it, and for some reason, I just read the whole article, but I can't remember where it was. It was just a few days ago, and it might have been in the New York Times, but it was precisely about kind of the average cost and county costs, and the fact that the counties have to bear this cost. Because there are county prosecutions. And it was talking about a few cases where, and these were in kind of like, ordinary Maine, the heartland U.S. This wasn't like New York City or anything. The cost of the capital litigation was going to be $800,000 to the county, basically. And so, these were where, the prosecutor just decides, look, this is not going to work. I mean, these are $800,000 that we could be using for something else, that the county could be using for something else. And so that is really having an enormous effect on prosecutors' decisions whether to go forward with it or not.
And then there's the cost disparity of after the conviction is sort of rendered and the sentence is rendered. And so when you are sentenced to death, you have a constitutional right to an attorney and to appeal. And so there's a state process that happens, a state direct appeal process, and then you seek cert in the U.S. Supreme Court. And there's a state post-conviction process that happens, you seek cert in the U.S. Supreme Court. And you keep going because you're being denied, but then you get into federal habeas and you go through that process. In Tennessee, which was sort of a middle-of-the-road state, it wasn't a Texas, like, quick to execute, it wasn't a California, very slow. But I represented individuals that had been sentenced to death in 1981, and their state post-conviction was just concluding in 2009. So, I mean, there's a cost associated with that. All the lawyers, the experts, the court, the fees, to defend the states that defend these sentences. And that actually raises maybe our final issue before we open up for questions, which is the length of these cases means that we are now have a very old death row. We have many people on death row who are very old. And many of the cases that have been recently at the Supreme Court have involved issues of old age. Madison, yeah.
Vernon Madison, dementia, question of dementia, whether dementia renders you incompetent to be tried. My client, Dole Ham, he had cancer. He'd been on death row for 30 years. He didn't have veins. So medical questions about methods of execution. It's true of Bucklew, too, who's pretty elderly. You know, in Alabama last year, as my case was going, there was another individual who was executed. He was 83. He was the oldest man to be executed at 83 years old. But all of these kind of an elderly population on death row raises different legal issues that the courts have to address.
And you're not getting good health care on death row. So your process is split up in some ways.
And there was some effort, at least this is last year, was trying to make an effort to to think about that issue of elderly people on death row and the special needs that are brought up. It was Breyer actually who was saying, you know, instead of dealing with or creating a special jurisprudence for old people on death row, we ought to just reconsider the constitutionality of the death penalty. But I actually think that's probably not the smart way to move forward strategically. I think it would be more effective for us actually to address these issues of old age, because we're just going to have increasingly old populations on death row. Which then serves as another kind of obstacle to executions and brings the numbers down further.
And what we didn't talk about is age on the other end. So most individuals that are sentenced to death, it's for acts they committed between the ages of about 18 to 24. And that's a key period because your frontal lobe in your brain is not fully developed. And so you have poor impulse control. You don't think about consequences. These are things we all know because we have been that age and we are that age. And so when you look at, you know, clients, and my clients in Tennessee, I think my youngest client was maybe 45. Most were in their 50s and 60s. They're not totally different people, but they are different people. You know, and I have a client who was 18 at the time of the crime. He's my client that's on federal death row. He's 34, he'll be 35 this year. And, you know, for the first time, he's had time to read and think and have fellowship. And, you know, I lament that our society, for young black men, doesn't create an atmosphere and a place for them to grow and learn and study unencumbered, you know, until they're on death row. Right. I mean, that's an extreme sort of sense, but for the first time, he's in a place where, you know, he's not sort of teased for doing well in school. I mean, it's just all these, you know, he's not punished and transferred schools for all these issues and in underperforming schools. So he can basically like receive books and read and fellowship and be creative and produce art. And why isn't that we're set up that he could have done that growing up, you know, before the crime happened?
Okay, so then let's move now back to the big picture with a final thought before we open it up to...
You didn't want to end on that low note?
Well, no, because I think all the building blocks that we've talked about suggest some optimism for the future of the death penalty, no?
No, you're right.
Do you agree?
I do.
Yeah? Yeah. At state level, and it's at the states that the work is going to need to be done strategically.
Yeah.
But gone are the days, and they were heydays, they were good days, when we thought that the court was going to, you know, rescue us, right?
Yeah, make our jobs obsolete.
Yeah. Okay, so let's open it up for questions from the audience. Yes?
Question, it wasn't touched on.
Hello?
Hi.
Yes. I'll stand up. I had a question about, I heard that sort of like nabbing Al Capone for taxes, the same way that like the formula, the actual lethal injection, part of the problem in Texas they found was that the people who produced it were in Europe, and the European companies, because maybe it wasn't economically feasible or because they themselves didn't support the death penalty any longer, so they stopped making it. And it was like yet another way, entirely outside of the courts, outside of the United States altogether, that made the death penalty more infeasible.
Yeah.
I don't know if you could speak to that, if that's
Sure.
actually a case, if that's
Definitely.
happening.
Yeah.
Yeah, it's happening all
Wanna talk
over,
about it a little bit?
and those are the tactics now. Did everyone hear the question? Okay, about lethal injection and the protocols, and so yeah, domestically, the drugs that are used that are identified in most state protocols, they're not really made by U.S. pharmaceuticals, but they're made in foreign countries. But many foreign countries, particularly in the UK, say, well, you can't use our drugs to kill people. So states, actual departments of corrections, were setting up these straw men. And I mean, one, it was like a storefront, I think. I don't know if it was
In
Oklahoma
London.
or wherever. Yeah, or
Yeah,
said
it was you got to look at the pictures. of
a
this.
made-up company that says, "Oh, this
yeah.
is we're going to buy
out
the
of the
drugs."
back, out of the back side of this kind of made-up storefront, they were selling the drugs basically.
Yeah, and so they were importing the drugs to this straw sort of middleman, and then the Department of Corrections were, getting the drugs. And in some instances, there were like parking lot deals with like cash and briefcases. These were state departments of corrections. And so, I mean, this was just like, candy and catnip for people that do death penalty litigation, because, that violates the FDA and all sorts of other things. And so there were lawsuits all over, Ohio, Tennessee, Nevada, California, North Carolina. There's a center affiliated with the University of Berkeley School of Law that just lost their funding that was helping to coordinate all the lethal injection sort of expertise. Like, this is what midazolam does. This is sodium thiopental, and these are the experts that you can use to have testify.
Right.
And in Tennessee, we sued the State Department of Corrections twice over their lethal injection protocol, and were able to put a hold on. There were 35 clients that we were representing in this one lawsuit against the Tennessee Department of Corrections. We were able to put that on hold. We lost. And so they said, the Tennessee protocol is fine, but the proof that we put up about midazolam and how it doesn't do what it's supposed to do was relied upon by the governor in Ohio that said, hey, midazolam doesn't work. We're going to put a hold on executions here. And there were folks, that had, I want to say it's David Stebbins, represented a man who had an actual execution scheduled for, it was like days away. And so they ended up giving a brief reprieve because of this creative litigation over the lethal injection protocols. And so there are a number of things that you can attack. The actual protocol, which are always covered in secrecy, and they've got prison guards that, don't have more than like a chemistry high school sort of expertise.
Yeah.
Having to participate in these executions. And everyone on the row knew who they were because they would practice how to do an execution like once, twice a year, I don't know what it was. But it's like, it was the same people that would go for this like practice run, and they had like nicknames for it. And so the discovery was fun during that. But you figure out who it is that's responsible for this and how grossly unqualified they are.
Right, yeah.
And how it's a day there was compounding sort of drugs that were being used, and you had that big health scare was in Massachusetts with compounding sort of drugs, and so this is a public health concern. It's not just death row, it's not just death penalty litigators, that are up in arms about this. This is a real public health concern for people in the state, and so it is another method, another means of attacking the death penalty, and it's a strategy used across the country.
Yeah, and it has had significant
effective.
effects.
Yeah, it's been effective.
We might be coming out of that period slowly, but it had significant effects. There was also some litigation against the drug manufacturers. So some organizations were actually suing the drug manufacturers because their drugs were being used in these executions against the kind of FDA approval, basically. Oklahoma was particularly interesting here because they were considering method of execution issues last year, and it was the commissioner of Oklahoma, I'm pretty sure, who ultimately decided they weren't going to use lethal injection because they can't get the drugs.
Yeah.
And that's when he decided to use nitrogen hypoxia, which is a new
Tennessee,
untested
brought back
method.
the electric chair.
Right.
Yeah.
Right.
Which they used twice last year.
Yeah. But there are often in these cases these other issues that then do present obstacles. You were mentioning protocols. Protocols are very interesting. In Alabama, the protocol is secret.
Yeah.
And so that
placed a lot of hurdles on the litigation of lethal injection. But what's interesting is that an organization at Yale and others on behalf of the Montgomery Advertiser sued the state and
Freedom of
actually,
information?
yeah, but they actually sued for access to the protocol, and the 11th Circuit held that they have to turn over the protocol.
Yeah.
So, but all of that also are different ways in which kind of there are roadblocks and delays, et cetera.
Yeah.
Yeah. Yes, Ian.
As it's shifting to a new type of political front going to the states, and we have governors, leaders like the presidential candidates that are taking the fight, so to speak, instead of through the Supreme Court. Is there polling on messaging that's working? I mean, if we're trying to convince a governor in Florida or Texas that's maybe a little bit more conservative, you mentioned that it swaps if they're proposing life imprisonment without parole as a better thing. Is there certain messages that are working better than others?
I don't know in terms of polls. I mean, I'm sure they exist. I have no doubt they exist. It's I don't want to say it's above my pay grade, but it's not quite my focus now is the packaging, but it's very much a part of it. And I think that there is this viable, more cost-effective alternative of life without parole is a very powerful message. And when you look at sort of the existing scholarship and what's getting produced and funded for scholarship, what kind of studies are getting funded. I mean, we say constantly that the death penalty is unconstitutional because of racial discrimination, but I think we're getting more creative about how we're making that argument. I think Brian Stevenson has been so effective at the Equal Justice Initiative with how he's talking about the legacy of slavery and the legacy of racial terrorism. When you look at each of these individual counties, the counties in the South that had the highest rates of racial terror and lynching against Black people are also the counties that have the highest rates of the death penalty today. And so this is looking at lynching, post-Civil War through Reconstruction, through sort of the Jim Crow period. Today in 2019, these are the counties, and that's a very powerful message. And so I think it depends on your audience, but I think that people are getting much more creative about what is the most effective sort of message for this audience member, and something that is very effective and can be effective in individual cases is defense-initiated victim outreach. So, at the time of trial, there's a lot of engagement and attention and media and a forum for victims to speak out. Often they can offer testimony at the sentencing hearing, and then after it just sort of goes away. And 25 years later, this case is still being litigated. And so, if somewhere during post-conviction or during federal habeas, the defense team, hires somebody, not directly within the team, so it's not an investigator that's out there, it's someone with expertise and training in defense-initiated victim outreach, reaches out to the victim's surviving family members and offers information. If you have questions about this process, if you would want any sort of correspondence, whatever it is that you want. And inviting also, you don't have to respond to this letter that I'm sending. But if there is an engagement, if there is communication, that can be quite powerful. And that was an element that existed within Dwayne Buck's case. Which, in the media with the Supreme Court decision, that really didn't get highlighted, but the woman she was shot and survived, and was related to the victim that had died, she was very outspoken about her support for Dwayne Buck and that he should not be executed. And she was at the oral argument in the Supreme Court. And so, depending on who your audience is, that can be, a method of really sort of packaging why this death sentence, why capital punishment in general shouldn't exist, because it doesn't necessarily bring peace to the victims.
Right. Yeah. No, I think that's entirely right. In other words, there are going to be different kind of situations in different places at different
factors,
times that are then going to be probably the most effective way of talking about the death penalty. I remember when I was in Illinois, when the governor put a moratorium on the death penalty in Illinois, where at a panel. He was, and he had a remarkably convincing way of speaking about it, which was he basically said, look, imagine you're running an airline, and you've got 12 flights that get to their destination, and you've got 13 flights that crash.
Yeah.
What do? Right? And they had 12 executions, or the other way around, 13 executions, or 12 executions, and 13 exonerations.
Yeah.
Right? And it's like, well, of course, you have a moratorium, and you try and figure out what's going on. And I thought, so there are always in these different particular moments in relationship to particular events, whether it's related to a particular method of execution that's going awry, as lethal injections have, or the problem of innocence, which was, which had, there was a period where the cases of exoneration seemed so compelling in terms of their numbers and whatnot.
Yeah. And in Illinois, the driving force was really the journalism department, I think, at Northwestern.
Yeah.
Yeah. And that was what worked in that state, and that was the reason that Illinois no longer has the death penalty, was just the sheer number of people that were exonerated.
Yeah. And the numbers of exonerations, I mean, they are pretty remarkable. Oh yeah, these are the numbers of exonerations, right? With a high point around 2004 of 12 exonerations. But overall, just a continuing stream of people who are being exonerated.
And there are some people not even counted on
Right.
that list because
Right.
they take sort of Alford pleas.
Right.
Which is when the state says, well, we have some evidence, we could, it's this legal fiction. We could prosecute you, and so it's basically their way of not being liable
Right.
for having incarcerated you wrongly for 2-3 decades. But in Dume Olatoshami in Tennessee is one such person who was he'd never been in the state of Tennessee. Was indicted for a murder and sentenced to death, and spent 20 years on death row, and then 7 in general population before he was released. And he chose to take the Alford plea because he could be released immediately, and then could continue to fight for his exoneration while out. But he's not, on that list. And I think the West Memphis 3, those young men,
Right.
there was one that was
Right.
under sentence of
Right.
death. I mean, they all took Alford pleas, and
Right.
so I don't think he's sort of,
Right.
reflected on that.
And of course, these are, absolute innocence cases. These are exonerations, right?
Yeah.
Not all of the cases where there's still, minor role or other issues.
or these legal fictions that exist.
Right. Other questions? Yes, Fonda.
So kind of taking it away from innocence and the big
Go ahead.
picture questions.
Okay, yeah.
Oh, is this working? Oh,
Yeah,
there we
okay,
go.
great.
I was just wondering, have you ever had people who actually work in the execution chamber come out and testify that this is a horrible process and this shouldn't go on? Like people who see the executions happen basically for their livelihood. Has that ever happened?
Yes, and that's another powerful sort of voice to have. I want to say that there was a warden who was from Texas.
Warden from Mississippi, Don Cabana, was an extraordinary man. But he had been the warden, he had overseen dozens of executions in Mississippi. And when he retired, he basically just came out against the death penalty and he really was changed by those executions. And he was remarkably convincing and compelling, and actually used him as an expert witness once to get a sense of a case and whatnot.
Yeah.
And he was remarkable, absolutely remarkable. And there's an association, I believe, of
Former wardens.
wardens and correctional officers who were involved in the death penalty and who it's impossible when you go through an execution or something, it's impossible not to see the way in which these executions affect all of the people that it touches. I mean, we think that it's just the inmate, but there are so many people who are affected by this, not just the attorneys, but prison guards, wardens, people who have to administer this, people who have to, find a vein and things like that. I mean, it's just, it's a huge number of people who are affected by an execution. And that's one of the things that we don't seem to realize or emphasize enough, really.
Yeah, the people that are on death row, they've often been there for decades.
Yeah.
And it's Unit 2 in Nashville, Tennessee. It's a community of people. And the prison guards have often also worked there for decades.
Right.
And the warden, maybe started out as assistant warden, associate warden, and then warden has been at that prison, that facility for decades. And can you imagine living in a small space, existing, in a small space, and you come in there and work every day, and these are the people that you joke around with, that you share meals with. And then, the next day, 20 years later, you're carrying out this execution. Of course, there's secondary trauma.
Yeah.
So you hear these reports, these stories, long-form journalism, the articles that come out, former physicians that were involved.
Yeah. There's no question, it's traumatic for so many people who are close to
Involved.
Yeah. Yes, Angel.
So I came in late, so I'm sorry if you already talked about this. But I was wondering, taking an approach that focuses on smaller incremental steps, whether you think that might undermine the abolition movement in the sense that it might make it seem less barbaric, or its barbaricness may be less salient. And I guess my thought is, like, when you talked about that Tennessee group, the conservative Tennessee group, like, let's say we accomplish some sort of rigorous standard for determining mental disabilities, like, then we lose that coalition. So just if you had any thoughts about that.
Yeah, I think that you can work on incremental, thank you, incremental change, and also highlight the how barbaric the death penalty is. I don't think those things are mutually exclusive. And because people who are working on these issues are often all the time in conversation with each other, I don't think those things are lost. And looking at the number of people that could get a death penalty, when you're able to narrow that number down, whether it's through serious mental illness, whether it's through extending Roper, which is the prohibition for anyone under 18, extending that to age 24, you're knocking out huge portions of who right now is eligible to be charged with a death-eligible offense. And I don't think there's anything sort of lost in still talking about how barbaric this whole practice is. I don't know if I'm totally answering your question, but I don't see those things as separately, working on the incremental change, and then really highlighting how inhumane and dehumanizing this whole system is.
Yeah, I think that's right. I mean, the only thing I would add to that is that, I've come to the conclusion that there really is not a nice way to kill a person. And that's the kind of conclusion I've come to. It's just like history is just replete with these efforts to find the best, simplest quicker way to kill people. And you look at the history of the death penalty, from the guillotine in France, right, which was intended to be a very quick, swift method, right? And the electric chair, which was intended to be a very quick, swift method. The electric chair was not intended to be a horrible, torturous experience. When Thomas Edison experimented with using electricity to kill an elephant, right? And from there on, it was thought of as being the best, most humanitarian way to kill. And that was true of lethal injection as well, right?
The late 80s, I think early 90s maybe?
Yeah.
Or 82 maybe was the first one? Or?
Yeah, it was at a time when people were really trying to find a way around the electric chair. The electric chair was horrible. But it was what was used as a humanitarian way of killing people, And then just the lethal injection comes in as this solution, and then it becomes clear that there are all these possibilities of, I mean, you were talking about the drug problems with midazolam and whatnot. I mean, the first attacks came because of the question of whether or not we were just sedating people so that we couldn't see them in agony, basically. Because it's a 3-drug protocol that was being used, and the first one was sedation, so that the person would be paralyzed, right? But if you're paralyzed, that doesn't mean necessarily that you're not feeling pain, right? Excruciating pain, which is, the third one is this kind of excruciatingly painful heart stop mechanism. But that's where it started. But then also we saw all of these other cases of not being able to find a vein, and the pictures that come out of these cases where they're doing, some kind of cut down measure, or where the drug has not gone into the vein but has gone into the flesh, and you see what the flesh. I mean, it's just so. I've just come to the conclusion that it's hard to kill somebody.
And that will always be true.
Yeah.
Even as you work on these smaller changes.
And so, and as a result, there just isn't a good way to do it.
Yeah.
So I don't think that those incremental challenges are going to have a negative effect. I think that they're actually challenging something that, meritoriously needs to be challenged.
Yeah.
Sorry, Lena.
Hi, first, thank you for being here. And second, I want to ask about 2 specific areas of the Nico Jenkins case in Nebraska, which was, it was a man who was in prison for like 10 and a half years, who experienced serious mental health conditions, schizophrenia, and he considered himself a danger to the society. And in fact, once he was released, he horrifically killed 4 people with a shotgun. And he, in fact, I think he sued the state for releasing him, if I remember. Anyhow, during this period of his spree of killing, the death penalty, the capital punishment, was overturned in Nebraska actually in 2015. So during this period, he was sent to a mental institution, I think, and the mental institution said, we do not have the security measures to take care of this. So they made an arrangement where, he was sent back to prison, but then they, sort of took care of him there at the prison. So in fact, he just went back to prison, and there was all of this talk. During this time, the capital punishment was put back on the referendum because of the Nico Jenkins case.
Yeah.
So I'm asking, I think, about these 2 specific veins of capital punishment. My first question is, I think we're also talking about mental health when we talk about capital punishment. I think they go hand in hand. And so how do we address mental health issues appropriately in cases like this? And my second question is how, if and when, we are able to get to a point where we overturn the death penalty and capital punishment in this way, how do we preserve that? Because as we can see, this was in a year's time from 2015 to 2016. It was overturned. So I think that that's also a fear, is how do we preserve that at the state and federal level?
Yeah. First, thank you for having me. It's been a pleasure. And these are hard questions. And you saw the same back and forth after Furman versus Georgia. The death penalty was off the table in 1972. They said, you're not narrowing it enough. And then in 1976, it's back on the table, and you have all these new statutes coming out. And then to address your question about mental illness and the death penalty, I think I said, nobody who has money is on death row. Nobody that is unscathed by trauma, ends up on death row. So all of my clients, every last one of them, and I've now been doing this for 11 years, has encountered childhood trauma. And it's not just their childhood. It was their parents' childhood. It was their grandparents' childhood. It was horizontally in the family tree. And these patterns of sort of behavior, patterns of mental illness, and undiagnosed. So, we collect symptoms. because grandmother wasn't getting a diagnosis, for post-traumatic stress disorder in 1940. But it's all there, and it really needs to happen at the before there's contact with the criminal justice system, which is just not in terms of the way that we provide resources in our communities and screening and services. It's not well done, and so I'm not entirely optimistic at our ability to eradicate the adverse childhood experiences, ACEs, and childhood trauma. But that would be the way to do it. But it needs to happen then upon appointment of counsel. I do a lot of trainings with death penalty lawyers, and I say that you need to have cultural competency. You need to recognize the signs and symptoms of mental illness through the lens of cultural competency. What seems normal to you, maybe isn't normal to your client, or the fact that you have a young black client who encountered a lot of violence and heard gunshots. That's trauma. It shouldn't be something that you cast off and say, well, all young black kids get that, which is what you see in a lot of these cases. I know I'm speaking somewhat tangentially on your question, but there has to be a real hard look done pre-trial at somebody's mental health and the signs and the symptoms that they're exhibiting, and then connecting it to the crime. And so many of my clients, because of how much they were exposed to, they've got this heightened hypervigilance. And there's an instance somewhere in the crime where they reacted to something in a way that was way disproportionate than what was warranted. And yes, maybe they were engaging in some criminal conduct, but they didn't plan for it to sort of occur the way that it did, because they were hypervigilant and reacted in this way that was totally informed by the way that they grew up. And that's not litigated well at trials. And so then we deal with it in post-conviction and federal habeas. And in terms of preserving, when there is a prohibition on the death penalty that's brought back on, it was really heartbreaking to watch that in Nebraska, because I think it was through the legislators that they voted to repeal it, and then it was back, and it's often because of this one really egregious bad thing that happens. And so I think it's about sort of educating the public. It's about educating your lawmakers. And I think Bernard, you really identified now that we have these mainstream politicians that are no longer running on tough on crime. And so I'm hopeful, that politicians can be nuanced about these things. I think about Colorado and what happened in Colorado with the Aurora theater shooting. He did not get the death penalty. He had really great trial lawyers, and part of that because it was such a high publicity case. I mean, the most talented sort of litigators in Colorado, and they have a state death penalty system, I think, and so they have really effective representation at trial, and there's a way of selecting jurors that everybody uses across the country, or they should use, and it's called the Colorado method. It was developed in Colorado. So they employed this Colorado method, and they were able to select jurors that had the thoughtfulness to consider what it is when you have a serious mental illness. Even though there are multiple murder victims, even though there were multiple gunshot wound victims, and I mean, the numbers, I think a lot of you remember, the news, I mean, the numbers were huge, and you look at sort of the disproportionality of other people in getting sentenced to death, and you're like, well, the Aurora, Colorado shooting. And so it takes time, and it takes nuance and thoughtfulness and mindfulness, which I know we don't really have a lot of in the general public anymore. You can fire off a tweet and things like that. But it takes a careful, thoughtful sort of packaging and framing of these issues.
Yeah. And it takes a lot of work.
A lot of work. Yeah.
And so I think we've learned two things. One, it takes a lot of work, and I hope that you all will follow in the footsteps of Alexis Hoag and help with that work, which is so desperately important. And the second thing is that there is hope, actually, because when you look at these numbers, I think you do see a reflection of the fact that there is something going on across the country, in communities across the country, about hesitations about imposing the death penalty, and a moral awakening as to these questions. So both a lot of work and a lot of hope. So I want to thank you, Alexis, for joining us at Columbia. It was extraordinary to have you here for this conversation. I know our students learned a lot, are inspired by your work and by you, and so I thank you very much for coming. And I think we can all join together in thanking Alexis Hoag.
Thank you. Thank you. It was a pleasure. Thank you.